Being unprepared is how great fathers become weekend visitors. I'm Jude Sandval, and this is Strategic Defense, the operational briefing for fathers who refuse to be sidelined by a system that exploits drift and unpreparedness. I ensure your mistakes don't become your permanent reality. While a lawyer handles your legal rights, I serve as your guide through the decision gap to protect your actual role as a father. You are now entering the command center. Today's briefing begins now.
Hello, dads, and welcome to this week's show and your briefing. We are going to start this week's episode by talking about, or this episode is actually going to be about the single most volatile legal and emotional battlefield in modern custody disputes. And I'm not exaggerating that. We're going to be talking about parental alienation. I know that a lot of you are experiencing it, and we get a ton of guys showing up in the community that are dealing with this. And if you're currently navigating a divorce, or if you're in the opening phases of a custody battle, you've likely heard this term. If this is new to you, then put everything aside and tune in very closely, because you're going to need to hear what we're going to talk about today. But you've probably read about it on blogs. You've probably heard other dads talk about it in support groups, particularly our support group, our dads meeting on the second and fourth Saturdays of the month. Or maybe, and hopefully not, but if so, you might be watching it happen to your own children in real time. Some of the symptoms, some of the signs are that you're watching them slowly withdraw. You're hearing them repeat adult language they couldn't possibly understand, or you're watching a campaign of quiet, systematic exclusion and gatekeeping designed to slowly nudge you out of their lives. But what you probably don't realize is also right now, while that's happening in your life, and in this exact news cycle right now, this week, there's a massive global, literal tug of war taking place over the very definition of this, and by extension, a definition and of your fatherhood. Really, we're witnessing two diametrically opposed legal movements happening at the exact same time on opposite sides of the spectrum of this parental alienation issue. And on one side, we have New Hampshire. The New Hampshire legislature recently passed House Bill 1323, which is the first law of its kind in the United States to formally define parental alienation in its state's statutory code, and it then mandates that family courts rule on these claims within a strict 60-day window. So it does those two. It does other things, but those are the two main things of the bill. It's set to take effect January of 2027 if the governor signs it. It hasn't been signed yet, but it's been passed through the legislature. And really, dads, this represents a historic step forward for fathers. It's a law that finally recognizes that alienating a child from a fit, loving parent is a severe form of emotional child abuse, and it sets up a rapid, and this is the huge part we're going to talk about later, why this is so important. It sets up a rapid response legal mechanism to stop it before the damage becomes permanent to your kiddos. Now, on the other side of this, unfortunately, and fortunately, on the other side of the border, we're witnessing a terrifying, it's truly terrifying counteroffensive, and I would say almost as bad as some of the compelled speech bills that have come out of Canada, or that did come out of Canada. So in Canada, a private member's bill called Bill C-223, called just hilariously Keeping Children Safe Act, is currently moving through Parliament. And if it wasn't so ridiculous, I mean, it's not really hilarious, it's just ridiculous. And it's currently moving through Parliament. If passed, Bill C-223 would fundamentally reshape Canadian family law by banning the concept of parental alienation from being used as a legal defense entirely. I know you're thinking, are you kidding me? This is the Twilight Zone. And yes, family court is often a twilight zone. And yes, Canada is often the twilight zone. Put them together, and I don't know if there's a level above the twilight zone. But the proponents of this bill are arguing that parental alienation is a pseudoscientific theory weaponized by abusive fathers to deflect from allegations of physical or sexual abuse. DV lobby again, right? And they want to make it legally inadmissible in any custody proceeding. So this is a global default line, and unfortunately, all this stuff crosses borders, and it's across the world, guys. I know I've got a ton of you guys listening, and all over 150, over 130 countries across the world, and more than 1,500 cities across the world, and Australia and UK and a lot in Canada also, and the majority here in the United States. So this is all prevalent, and the parental alienation just is not in one place or another. And it is a proven devastating form of emotional child abuse that must be aggressively prosecuted to protect the child's bond with both parents. It's important with both parents. So this legal maneuver is designed to silence abuse. Well, they claim so. Let me step back. The fault line is this: is parental alienation a proven devastating form of emotional child abuse that must be aggressively prosecuted to protect the child's bond with both parents, or is it a tactical legal maneuver designed to silence abuse victims and put protective mothers on the defensive? So that's the fault line that we're talking about and that we're dealing with. And so what I'm going to do today is we're going to do a deep dive into this legal tug of war, because you need to know about it. And we're going to unpack the exact mechanics of the New Hampshire's HB 1323 and Canada's Bill C-223. And we're going to look at the actual peer-reviewed science that debunks the Canadian narrative, and we're going to look at how these dueling laws affect your custody strategy on the ground, no matter what state or country that you live in. And then most importantly, I'm going to show you and explain to you how to navigate this tilted arena so that you can protect your children's history and ensure your role as a father remains a permanent reality. So let's jump in. This is unfortunately the state of the tactical defense that you have to take for your kids. And let's first talk about the New Hampshire bill and what I would say is the progress side of the ledger or of this fault line, right? Because what the New Hampshire legislature did with this bill, I feel, is a massive historic victory for fit and present fathers. And to understand why it's so revolutionary, we have to first understand the single greatest weapon that an alienating parent has in the family court system. And that weapon is delay. And you've heard me talk about it. You heard me talk about your drift, and that's what happens when there's a delay is you start to drift. Under the current system in almost every state, if your ex-spouse or your soon-to-be ex-spouse begins gatekeeping your children, canceling visits, or systematically excluding you from school and medical decisions, your only present recourse is to have your attorney file a motion for enforcement or modification. But because family courts are managed by overworked judges with dockets running at 120% capacity, that motion oftentimes sits in a pile for 3 or 6 or 12 months before you ever get to a hearing. And then while you are waiting for that hearing, the alienating parent is busy establishing a new status quo. They're spending those 9 months, 12 months, whatever it is, systematically conditioning your children to see your time as optional and their home as the only default reality. They're also rewriting the child's memories. They're seeding the idea that you might have abandoned them. And by the time you finally stand in front of the judge, the academic and clinical reality of parental alienation is already set in. We've heard Charlie McCready on the podcast and in our sessions talk about pre-alienation. This is what happens. The child now is anxious. they're resistant, or maybe they're even openly hostile to you. And the judge, because they're looking for, right, the courts work on efficiency and risk mitigation, the judge looking for the path of least resistance to close this file is going to look at the child's current state and say maybe something to the effect of, well, the child seems settled, the child seems happy here in the routine. It's just going to be too disruptive to change things. And guys, I see guys that have not experienced this yet. I see it all the time. This is not made up, and is definitely not far-fetched. And so this process of delay is what allowed the alienation to succeed. The system itself participated in the erasure of your fatherhood simply by doing nothing for that time frame, 9 months, 12 months, whatever it might be. But the good news in this New Hampshire bill is it targets this delay mechanism with precision. First, what the law formally does is it defines what parental alienation is, which is great. It says the statute defines it as a pattern of behavior, conduct, or speech that would damage the relationship of the child and a parent, resulting in the child's fear, negative perception, rejection, or hostility toward the other parent. It explicitly lists the behaviors: communicating disparaging remarks to a child about the other parent, manipulating or coercing a child, and unjustified interference with parenting time. So it doesn't just define it, it defines specifically what the behaviors could be. And so by putting this definition into the statutory code, the law removes the gray area of judicial discretion, right, which is what kills us. A judge can no longer look at a mother gatekeeping a child and dismiss it as post-divorce bickering or communication issues, etc. It is legally defined as parental alienation.
Stay with us. We'll be right back.
Hey, dads, Jude here. I'm pausing this conversation for a mission-critical warning. Everything we discuss on this podcast only works if you have a role to return to. Most fathers don't lose their kids in court. They lose ground quietly through drift and decisions made under pressure. Being unprepared is how great fathers become weekend visitors. I ensure your mistakes don't become your permanent reality. Stop the drift today at thedivorcedadvocate.com. Take the free weekend visitor risk assessment or book your fatherhood protection session. Your kids are counting on you. Now, back to the show.
The second thing, and this is the tactical sledgehammer that this law expands, is that use of family access motions and mandates a strict 60-day timeline. If an aggrieved parent files a motion alleging parental alienation or substantial noncompliance with a parenting plan, the court must hold a hearing and issue a ruling within 60 days of the filing. So think about the power of that 60-day clock compared to 12 months. It completely neutralizes the alienating parent's delay tactic. And it means she can no longer use the court backlog to buy herself that 9 months, 12 months, whatever it is, to alienate your child and establish a lopsided status quo. If she gatekeeps, she's in front of a judge in 8 weeks, not 8 months. It is beautiful. Another part of this law that I didn't mention earlier is that it mandates, and this is fantastic too, right? Because without deterrence, people are still willing to do some of this stupid stuff. The law mandates real punitive consequences. So if the court finds and again, just by a preponderance of the evidence, that parental alienation has occurred without good cause, the court is statutorily required to order a remedy. And this the remedy isn't a verbal warning. The law specifies that the court can order immediate makeup parenting time, that time taken, time back that Robert Garza is working on, or modify the permanent custody orders, or restrict the alienating parent's decision-making authority, and critically award attorney's fees to the aggrieved parent. So this actually is a law that has a little bit of teeth. And I really feel this is a blueprint for how you protect the parent-child bond under fire. It recognizes that a parent who is willing to manipulate a child into rejecting the other parent is, by definition, acting contrary to the child's best interest and is engaging in a form of child abuse. And that's a beautiful part of this, because nobody wants to define best interests. They leave it so loose, up to the judgment of the judges and the courts. And then that is what it makes it so easy to sideline dad. So this forces the system to act before the infection has time to become a permanent disease and your permanent legal reality, dads. So that's the New Hampshire bill. But hey, you heard me talk about it a few weeks ago about the dichotomy of this. And while we're getting some of these equal shared parenting laws passed in some states, that there's a whole other contingent that is working hard to do the exact opposite of this. And so while states like New Hampshire are moving toward protection, Canada is literally moving towards a complete ideological shutdown of paternal rights. And this really, I'm going to talk about it, it crosses genders because it's very dangerous what they're doing here. So let's look closely at this Bill C-223, because it's the ultimate expression of an ideological movement that's actively trying to eliminate fathers' ability to defend themselves in court. And we just had it happen here in Colorado. You heard me talk about that on a previous podcast as well. This bill, formerly known as what I told you, the Keeping Children Safe Act, right? Ironic, was introduced as a private member's bill with backing from prominent domestic violence organizations. No surprise there, dads. On its surface, the bill's packaged under the banner of child safety, hence the ridiculous name. But when you analyze the actual statutory provisions, you realize very quickly the bill is a direct systematic assault on the legal and scientific framework that protects the father-child relationship. So if passed, what Bill C-223 would implement is 4 catastrophic changes to Canadian family law. Let's go through them. The first is it would render any claim of parental alienation completely inadmissible in family law. Let me read that again, because I know you're like, this is the Twilight Zone. I'm not hearing this right. First, it would render any claim of parental alienation completely inadmissible in family court. An attorney representing a father or anybody would be legally barred from introducing evidence that a mother or anybody is systematically brainwashing, coaching, or manipulating the children to reject him. The very vocabulary of alienation would be outlawed in the courtroom. Crazy. Second, the bill would prohibit judges from ordering custody reversals in response to even the most extreme documented cases of parental alienation. Under current law, if a parent is found to be engaged in a severe campaign of parental alienation that's destroying the child's psychological stability, the court can transfer primary custody to the targeted parent to preserve the bond, which makes sense. But Bill C-223 would strip judges of this authority, leaving them absolutely powerless to protect the child from the alienator. Third, the bill would ban reunification therapy. I mean, this should be called the child abuse bill. I mean, it makes absolutely no sense. It would ban reunification therapy. And for those of you who aren't familiar with what reunification therapy is, this is the specialized clinical therapy designed to repair the parent-child bond after a child has been alienated or separated from a parent for a long period of time. And so by outlawing this therapy, the bill ensures that once a child has been successfully alienated, there's no legal or clinical mechanism allowed to heal that relationship. The erasure just becomes 100% permanent. And the four and the fourth one and the last one, and here's the cherry on top, right? It would remove the requirement for corroborative evidence. God, I'm having challenges with a couple of these words today. Corroborative evidence when making claims of intimate partner violence. What does that mean? It would allow a party to make an allegation of abuse without any police reports, any medical records, or third-party witnesses, and have that uncorroborated allegation function as a legal presumption to restrict the other parent's custody. At the same time, it would significantly lower the barriers for a custodial parent to relocate with the children to another province or country without the other parent's consent. Okay, those are the four basic things. And I know you're like, this is insanity. Yes, it is insanity, but you've got to understand where the other side is coming from. They're desperate at this point where we're getting bills in Kentucky and North Dakota and New Hampshire in other states that are getting 50-50 and then the New Hampshire bill as well that's enshrining parental alienation. So they're desperate to really do this the absolute other way and push this as hard as possible. So in short, this Canadian bill C-223 makes it incredibly easy to make an unproven allegation of abuse to sideline a father. It makes it effortless to move the children away so he can't maintain contact. And it legally outlaws his ability to claim that she is alienating them or to seek therapy to rebuild the bond. So it is brutal. And like I said, the driving ideology behind the bill is a theory popularized by certain feminist academic circles, which claims that parental alienation is a fake, unscientific concept invented by, let me give you one guess, abusive men. An unscientific concept invented by abusive men. And they argue that whether a mother alleges that when a mother alleges physical, sexual, or emotional abuse in a custody dispute, the father's standard response is to claim she is alienating the kids. They claim that family court judges, biased in favor of fathers' rights, routinely ignore real evidence of abuse, accept the parental alienation defense, and punish protective mothers by taking their children away and handing them to abusers. This is the narrative being read in the Canadian Parliament. But when you look at the actual quantitative data in the peer-reviewed research, you find that this narrative is not just oversimplified. It is a complete 100% data-distorted fiction. It's literally the Twilight Zone. Let's look at the actual science, because if you dads are gonna fight this battle, if we're gonna fight this battle together, we must do it with the clinical weight of peer-reviewed data and not with the ideological slogans, the father's rights, et cetera, which is, there's nothing wrong with that, but we need to support it with the peer-reviewed data. So first, the claim that parental alienation is a junk science used primarily by abusive fathers is flatly contradicted by decades of mainstream psychological and sociological research. First, let's address the reality of parental alienation as a behavior, and this crosses genders. Parental alienation is recognized in peer-reviewed literature as a severe, devastating form of coercive domestic abuse. When a parent, dad or mom, systematically denigrates, lies to, or manipulates a child into rejecting the other parent, they are not just harming their ex, they are engaging in emotional child abuse. Decades of research by prominent developmental psychologists like Dr. Richard Warshak, Dr. Linda Nielsen, Dr. Edward Kruk, they all demonstrate that children subjected to parental alienation suffer profound long-term psychological harm. They show significantly higher rates of anxiety, of depression, low self-esteem, substance abuse, and clinical indicators of trauma. And in adulthood, these children face massive struggles for forming healthy, trusting relationships because their early attachment templates were systematically distorted by the alienating parent. This Canadian bill seeks to outlaw the very legal category that identifies this abuse, effectively leaving children completely unprotected from one of the most insidious forms of emotional violence. Insane. Second, I've said that a lot, insane, because it just seems insane. Like anybody can think about this and look at this and just think it's crazy. Second, so let's look at the gender data, because this is an important one. This is what, as far as I'm concerned, the one that just destroys it. The proponents of Bill C-223 operate on the assumption that parental alienation is a gendered weapon used by men against women. But the empirical data shows that parental alienation is a completely non-gendered behavior. And a major representative study of Canadian adults conducted by researchers in Canada, Denise Hines of George Mason University and Alexandra Lisova of Simon Fraser University, examined the prevalence of parental alienation. And the data was clear. 6.3% of Canadian adults reported that their mothers had actively tried to damage or destroy the relationship with their fathers, compared to 4.6% who reported the same behavior from their fathers. So and that's just one. Like we can find more, but that's just one. This isn't a gender issue. Parental alienation is not a men's rights invention. It is a behavioral pattern executed by high conflict personalities of both genders. By banning the defense of parental alienation, the bill doesn't just harm fathers, it actively disenfranchises safe, protective mothers who are dealing with abusive, alienating ex-husbands or soon-to-be ex-husbands. That alone just destroys their whole argument. But third, let's add on more. Let's dismantle the abuse shield narrative, because this is the DV's other big thing. And here's the crux of it. This stuff goes away. Their funding all goes away. They're almost 99% women focused, and all of this stuff goes by the wayside. So that's the reason why, which we've talked about before. But the driving argument is that fathers use parental alienation claims to bypass or cover up legitimate claims of physical or sexual abuse, and that courts routinely award custody to abusive men as a result. There's no documentation of this, by the way, but a comprehensive peer-reviewed meta-analysis of family court rulings published in Psychology, Public Policy, and Law by Dr. Jennifer Harmon and Richard Warshak examined how parental alienation claims actually impact judicial outcomes. So what it analyzed was thousands of custody cases. And what it found was that when there is credible, documented evidence of physical or sexual abuse, family court judges do not ignore it in favor of alienation claims. The safety of the child remains the paramount statutory consideration in every jurisdiction, and a finding of abuse routinely overrides any other factor. That's why they're coming up with this whole coercive control idea and leaving it very subjective, because now they're losing on this battle, which is the system is actually working when there are credible documented evidence of physical or sexual abuse. The courts are doing something about it. So that's happening. The court system's working, but it's not enough for them. The reality is actually the exact opposite of what the Canadian narrative is. The high conflict alienators who routinely use the system's low civil standard of proof, 51%, right, preponderance standard, to file false, uncorroborated allegations of abuse as a tactical first strike, right, the silver bullet, to restrict the father's access and initiate the process. So when we look at the objective data on child welfare, the stakes of this legislative fight become visceral. Long-term studies from the U.S. Census Bureau and family justice organizations track the outcomes of children who are alienated or separated from their fathers. The numbers are devastating. Children raised in fatherless homes are 4 times more likely to attempt suicide. double the risk of committing crimes and face significantly higher rates of drug addiction, academic failure, and incarceration as both youths and adults. So by making it legally effortless for one parent to unilaterally remove the other from a child's life through uncorroborated claims does not keep children safe, like the bill's title. It systematically manufactures the exact family breakdown the family breakdown structures that developmental science has proven and states are most destructive to children's lives. All right, so now you see the insanity around all of this. And if you don't see it as insanity, I don't know what to tell you, but you've got to be warned about this, dads. And this is why I do the work I do. This is why I do the coaching, because so many dads show up and go, oh my God, like, I can't believe that this is happening. Won't the courts just see? Won't they understand? I'm a good dad. I've been a good dad. Does not matter. It matters in the moment of what's happening and what the allegations are. So you've got to know what the machine does and how you feed it. So what does the legal tug of war mean for you? And on the ground, what do you need to do in your active custody case? It means you have to realize you're operating in an environment where the definition of abuse is being stretched to its absolute limit. And like I said, with the coercive control, they're trying to even codify this stretch into something that's just completely subjective. And where your high conflict, soon-to-be X or X is being handed a highly sophisticated legal playbook designed to put you on a permanent defense and completely sideline you, completely erase your parental authority. So if you're currently in a custody battle, you can't wait for your state to pass laws like New Hampshire's to save you. You have to assume that the system in your jurisdiction is already highly susceptible to the woozles. You heard me talk about woozles last week in the maternal preferences that drive the Canadian model. Woozles are things that are said over and over and over again that have that are unsubstantiated, that then the courts start to believe, like the tender years doctrine. That was what we talked about last year. Look it up. It's actually a real thing. So, but if you're going to protect your role as a father, you must execute a clinical forensic documentation strategy that makes her alienating behavior visible and her false allegations completely indefensible. So how do we do this? All right, here's the strategy part, guys. Listen up. You do this by moving from venting to strategic intelligence gathering using the narrative building protocol. You've heard me. I've done a whole podcast on this of how to do your documentation, and you must systematically document her behavior across the 6 specific categories. Now, I'm not going to go, I actually had all these listed out and I was going to go through them, but go back to the documentation podcast. It's about, I think it's about 4 or 6 podcasts prior to this one. And I lay out in there specifically what they are and what you need to do. I'm going to review them here, but I'm not going to go into the details of them. The 6 specific categories are: the first is exclusion, and that's her systematic attempt to erase you from the daily administrative loop of your children's lives. The second one is gatekeeping, any attempt to physical or logistical to limit your access to the children or deny you your court-ordered parenting time. Third, interference, actions designed to disrupt the emotional bond between you and your children. Fourth, control. This is her systematic attempt to micromanage your parenting, your environment, and your schedule. And again, guys, in the other podcasts, I'll go back and I'll give you very specific examples of the behaviors, and then also what you need to do in order to document it correctly. And again, this is part of the Bulletproof Dad 90-day protocol that we work on in session and teach you how to put this together, how to make it court ready for your attorney to utilize and then submit to the court. So go back and listen to that podcast episode. And the fifth one is tactical, and these are the strategic silver bullets aimed at your reputation. And then the sixth one is flexibility, and this is your most critical category, because this is the one where you're documenting your own fitness, your cooperation, your high road leadership, your ability to work as a co-parent and be a positive father and an involved father. So that sixth one is equally as important to the other five, which is documenting her less than good behaviors. So, dads, this is a lot. And, what this global tug of war proves is that the battle for your role as a father is not just happening in your local courtroom. It's an active, high stakes, ideological war. I'm going to have a podcast coming up from a gentleman that dealt with this over in Europe. And so we're going to be talking about his challenges there. And so whether you are operating under a progressive framework like the New Hampshire bill, or fighting against the hostile legal climate represented by Canada's bill, your objective does not change. It remains entirely the same. You cannot rely on the system to naturally protect your bond, nor can you afford to let frustration dictate your response. Your strength lies in unwavering composure. It lies in meticulous documentation. And it lies in absolute refusal to be baited out of your children's lives. Frame by frame, log by log, you are building an undeniable record of truth that no amount of spin or delay will be able to erase in court. So dads, stay steady, keep your state regulated, and execute the strategies that we've talked about in here, or schedule some time with me at talkwithjude.com, and we will do a quick triage of what you've got going on and see where we can point you in the right direction. This, dads, is the tactical defense for your fathers. So I hope that you found some value in this. Please share far and wide with dads. We are all over the world, dads, and all you dads listening everywhere. Just know that there is the common, the common bond of the fight and challenge that we're undertaking here across the world to maintain our parental authority as really good, engaged, and loving fathers. So keep up that fight, and please stay strong. Leave us a star rating. Give us a comment, share this on social media, do whatever you can do to help put that ladder down to the next guy to get him, that dad, the help that he needs and deserves. So thanks so much for listening this week. God bless, and we'll talk to you next week.
This concludes today's briefing. Remember, in the family court system, intelligence without execution is liability. Ground is lost quietly during the decision gap between your court hearings. Being unprepared is how great fathers become weekend visitors. I ensure your mistakes don't become your permanent reality. Secure your role today at thedivorcedadvocate.com. Take the weekend visitor risk assessment to identify your exposure, or book your private fatherhood protection system. Stay strong. Your kids are counting on you.